Hi, this is Scott Stork with Polaris Law Group. We're an estate planning and elder law firm here in St. Charles, Missouri, and today I want to talk to you about the 12 missing powers that a lot of powers of attorney don't have. But before we get started, I want to remind you to hit the subscribe button so that you have access to all of the videos that we do, and we'd love to get comments from you in the comments section. So let's talk about the 12 missing powers that powers of attorney don't have. So first, what's a power of attorney? So there's different types of powers of attorney, but the most common ones that we see are legal and financial powers of attorney. So here in Missouri, a lot of times they're called general durable powers of attorney, meaning that they're powers of attorney that are still valid even after somebody becomes disabled. So what's a power of attorney? A power of attorney is simply the authority given to someone to step into your shoes to make decisions for you at various points in time. There are also medical powers of attorney, healthcare powers of attorney, that basically do the same thing. It's somebody who can step into your shoes if you're not able to make decisions about your healthcare, who you authorize to make those decisions for you. One thing to remember about powers of attorney is that they're only valid while you're alive and well, or alive and disabled. Once you pass away, a power of attorney is no longer valid. It can't be used by anyone, so there's really nothing that can be done with a power of attorney after your death. But they sometimes are the most important documents that clients will do when we're doing estate planning. So let's talk about what those 12 powers are that that have to be what's called enumerated in Missouri. So enumerated means you actually have to have them in the document. And so if we go back to the beginning of what a power of attorney is, we review a lot of these power of attorney documents, and we'll see powers of attorney that are 4 pages. I've seen powers of attorney that are 2 pages, which includes a signature page. We see a lot of 5-page, 6-page powers of attorney. And most of the time, those powers of attorney probably aren't doing enough to actually help someone when it's necessary. So remember, no one has a legal right to be able to make decisions for you unless you give them that right, or unless a court gives them that right. So if you don't name your spouse as your power of attorney, if you don't name your parent as a power of attorney, if you don't name your child as a power of attorney, none of those people have an automatic legal right to make decisions for you, unless they go to court and are granted what we call guardianship or conservatorship. So most of us know we want to stay out of court, so doing these powers of attorney is a very important step in planning for our future. So let's talk about the powers that Missouri law says have to be enumerated or actually written in a power of attorney for them to actually be valid. Some of them are going to be more important than others. Some of them belong in one power of attorney as opposed to another. So let's start with number 1. The first one is the ability for your power of attorney to make a trust for you. So this can be pretty important. Sometimes we need trusts to be made for various reasons. So simply, a trust is just something where we can put our property and assets in to achieve a certain goal. So for our clients, a lot of times they do revocable trusts, and they are trusts that help plan for protecting sometimes assets during lifetime. They help plan for disability if we do become mentally disabled. They help avoid the probate process, which we know we don't want to be in. So as long as we have things in our trust, it avoids probate, and it can protect the inheritance that we leave to our kids or direct where we want that inheritance to go. There are also irrevocable trusts, which are trusts that sometimes are used for qualifying for Medicaid, so we don't have to pay for nursing home care costs. Sometimes they are used for planning for estate taxes and other types of taxes. There's all sorts of different irrevocable trusts. But one of the enumerated powers, and sometimes something that we need people to do for us, is making a trust. Most of the time we review powers of attorney that come from other lawyers or online or things like that. Those powers are not present in that power of attorney. The second power of attorney is the ability to what's called fund a trust that's made by the power of or by the person signing the power of attorney. So, for instance, if we want our kids to be able to make a trust for us potentially, we also may need them to be able to do something called funding. So we have other videos about what funding is, but simply put, funding is filling the treasure chest. So if we kind of use the treasure chest as our example, and we've got this treasure chest, if we dig up an empty treasure chest, it's not worth anything. Well, we have to actually put your property in assets into the trust that's created for it to actually make any difference at all. So your house, your bank accounts, your life insurance, whatever that might be, whatever we can get into the trust, we need to do so in the appropriate way. And a lot of times we need people to do that for us if we haven't done so in advance. So funding a trust is incredibly important. Another power that we have to enumerate in our power of attorney. What about making a gift or revoking a gift of property into a trust? What if we need to make a gift into an irrevocable trust because we are afraid that we're going to lose all of our money to the nursing home? What if we have a trust that we've put property in, but now it needs to be taken out? Well, we need to enumerate those powers in the power of attorney. Disclaiming a gift or disclaiming what's called a power of appointment. So a disclaimer is just, hey, I don't want this. So sometimes if you receive a gift or something like that, it could cause problems. It doesn't happen often, but it does sometimes. So maybe you need your power of attorney to say, hey, because I'm being informed that this could be an issue, I need to disclaim or let this gift bypass my person that I'm the power of attorney for and go to somebody else. Or disclaiming what's called a power of appointment, which is just simply, if I create a trust, my power of appointment is my ability to say where my trust share, what I'm receiving in the trust, goes after my death, or to who it goes to. So maybe there's an issue where that power of appointment is going to cause problems. We may need the power of attorney to be able to have the power to deal with that power of appointment. Next is changing a survivor interest in real property or designating or changing a beneficiary in real property. Both of them dealing with real estate. Both of them are things that a lot of people, including a lot of lawyers, don't know actually have to be enumerated, actually have to be have some other formalities done in the power of attorney to deal with. So, for instance, if we want somebody to be able to name where our house goes to after we die, and we haven't done that in advance, and we want to stay out of the probate court, we better give them that authority to do so. So this one is one of the most important powers that a lot of powers of attorney, or most powers of attorney, don't have, that can cause real issues for people down the road. The seventh one is where we kind of start the healthcare power of attorney powers. So one of them is the ability to consent to an autopsy. So my partner Ray and I just had this happen. We had somebody who was pretty sure that there was going to be some sort of personal injury claim for their parent that had just passed away. And one of the ways to prove that was to be able to consent to an autopsy. This was a family where the kids didn't get along. The parent didn't do a power of attorney. There was nobody that had the ability to consent to the autopsy unless all of the next of kin, which were the 3 kids who don't get along, agreed. So because those 3 haven't been able to agree, didn't agree, then all of a sudden an autopsy couldn't be performed, and now we may be having an issue where potentially somebody's not going to get a personal injury award that they may be entitled to. So the ability to consent to an autopsy is a huge deal, something that we absolutely want in a power of attorney, but again, we have to actually enumerate that power. The next one is the ability to make anatomical gifts, to be an organ donor. Again, lots of people want to be organ donors. If we don't say that our power of attorney has the right to make that decision, then nobody that can't be done for us. The next is something that's really important: the right to nominate a guardian or a conservator. So a lot of times, if we don't do powers of attorney, then someone has to go to court to become our guardian or our conservator so that they can make decisions for us. Now, this is if we become disabled or something like that. What the power of attorney can say is, if we want, let's say, our spouse or our child to be able to go into court and say, I'm the power of attorney and I have the right to name even myself as the guardian or conservator, we want that to happen because a lot of times we don't want a judge to just make a decision that might be contrary to our wishes. So what if we know that we have other kids and we don't want one or two of them to be our guardians or conservators, but they go into court to try to fight it? Well, a judge could, if we don't do this power in our power of attorney, could name anybody, even somebody we might not want to have that position. So having this in there is really important if we know that we want our power of attorney to also be given those guardianship or conservatorship duties if it's necessary. The next one is the ability to consent to medical care. So again, back to the medical power of attorney. If we want someone to be able to make healthcare decisions, we better do a healthcare power of attorney and not just rely on a general, durable, legal, and financial power of attorney. The 11th one is to substitute successor powers of attorney. So what if we want our power of attorney to be able to name a backup to them if something happens to them? So for instance, what if we've done a power of attorney and we've named our spouse and two of our kids, and something happens to one or both of those children? Maybe we want our spouse, maybe we want our child, whoever that power of attorney is, to be able to name somebody to back them up just in case. So doing this can be really important because it's going to allow them to kind of plan just in case something happens to them. And then finally, the last one is to make use of a power of appointment. So again, talked about the power of appointment is the ability to state where our trust proceeds go if we inherit. Well, the power of appointment is an incredibly important part of trust planning. And if we don't give our power of attorney the ability to actually utilize a power of appointment, if we haven't done it already, it can cause real problems down the road. So all of those enumerated powers are things that have a very specific reason that we want them in the power of attorney document. Again, most of the ones we review lack most of these powers. And so when you pick a lawyer to go through and do a power of attorney, to do other legal documents, you want to make sure they actually are very well aware and have got some sort of specialization or expertise in what they're doing, because if they don't, then you run into that 4-page, 3-page, 2-page, 5-page, 6-page power of attorney, and I can almost guarantee none of these things are inside of that. So again, 12 things that you have to enumerate in your powers of attorney that most power of attorney documents don't have. I hope that was helpful. Again, remember to subscribe to the channel, get all of our upcoming videos. If you have any questions or comments, put them in the comment section. But again, I'm Scott Stork with Polaris Law Group, and I hope this is helpful. Thank you.